Hello, and welcome to Talking Turkey. I'm your host, Ahval editor David Lepeska, and with me today is Nicholas Ioannides, adjunct professor at the University of Nicosia and an expert on maritime law. Hello, Nicholas, and thank you for joining us today.
Hello, David. Thank you for inviting me.
You are welcome. Before we begin, I just wanted to say there's been an incredible amount of tension surrounding Turkey-Greece maritime issues in recent days, which we are going to discuss. I myself was involved or semi-involved, I guess, in a days-long, very animated Twitter debate in the past week or so that involved dozens of voices from both sides. I'm guessing you've seen some of this as well, Nicholas. So I just wanted to say before we start that despite you being a Greek Cypriot and potentially seen as biased, and me working for a news outlet that many people see as anti-Erdogan and anti-Turkey, I just hope we can have an impartial discussion on law and rights rather than about who's the aggressor and who's the aggrieved.
Well, yes, I'm an academic, so my aim is to present the situation through the legal norms of international law and not doing politics.
Perfect. Okay. So yeah, we are speaking on Monday, September 7th, 2 days after Turkish President Erdogan, amid these sky-high tensions between Turkey and Greece that I mentioned, warned Greek officials that they better begin negotiations over Eastern Mediterranean territorial claims soon, or, quote, they will understand that Turkey has the political, economic, and military strength to tear up immoral maps and documents. Thankfully, we have you, Nicholas, here today to nail down precisely whose maps may or may not be immoral. Before we get to the maritime deals Turkey and Greece signed with North African allies in the past year, I wanted to look at their competing claims in the Aegean and Eastern Mediterranean. Now, as I understand it, as a total neophyte, in 1982, the United Nations Convention on the Law of the Sea extended a country's maritime rights from 3 nautical miles off its coast to 12 nautical miles and provided for a possible continental shelf length of up to 200 nautical miles, known as its exclusive economic zone, or EEZ. Greece ratified that convention and now uses it to assert that its islands allow it to claim almost all of the Aegean. And this does not include the sizable area claimed by the Republic of Cyprus around that island, which Athens also supports. Turkey understandably disagrees. Ankara has not ratified the Convention of the Law of the Sea and says the two states should negotiate one-on-one, while Greece calls for adjudication by an external body such as the International Court of Justice. Nicholas, I probably got some of this wrong, so please, if you would, clarify the maritime dispute between these neighbors, which has brought them to the brink of war, and please, if you would, provide a bit of historical background.
Yeah, thank you. So the Aegean conflict broke out in the 1970s between Greece and Turkey. It was then when significant amount of oil was discovered of Tassos, the Greek island of Tassos, and then Greece started conducting oil exploration activities. Turkey wanted its share from that bonanza, so it deployed survey vessels in the Aegean as well. So we had a case before the International Court of Justice in 1976 and 1978, where the court found that it did not have jurisdiction to address the dispute, but this did not end the dispute. It's been ongoing since then, but there's a moratorium of activities in the Aegean since the 1970s. You referred to the continental shelf, which is a distinct maritime zone than the Z. The continental shelf refers to the subsoil, the geological extension of the territory under the sea, and the EZ includes both the subsoil and the subjacent waters. So it's a combination, but they remain two distinct zones. Neither Greece nor Turkey have declared an EZ, but they do have, they automatically have a continental shelf. A state does not need to declare a continental shelf. It belongs to it automatically, ipso facto and ab initio, as the International Court of Justice said in 1969. So, whereas the Aegean conflict has been ongoing for several decades, in the Eastern Mediterranean, the situation, the dispute erupted in the early 2000s when significant hydrocarbon discoveries were made by Israel and Egypt. And then Cyprus took the initiative. It signed delimitation agreements with Egypt, Lebanon, and Israel. That did not like, Turkey did not like that. So they reacted. They sent letters to the United Nations rejecting those agreements, arguing that Cyprus does not have the right to claim maritime zones. Of course, as you know, Turkey does not recognize the Republic of Cyprus. So there's an ongoing conundrum over the last 15 years. Turkey sends its warships in the waters around Cyprus, trying to, on the one hand, to prevent Cyprus from carrying out hydrocarbon activities, but on the other hand, to conduct its own hydrocarbon activities. As we speak, a Turkish drill ship called Yavuz operates within Cyprus's continental shelf and EZ in the southwest, and a survey vessel, the Barbaros, operates off the southeastern coast of Cyprus. So that's a very general picture of the situation at the moment.
Before we get to Cyprus, I just wanted to say that the tiny Greek island of Kastellorizo, a few miles off the coast of southern Turkey in the eastern Mediterranean, is a key issue here. In fact, it was Turkey moving to begin seismic activity near Kastellorizo last month, backed by naval vessels that prompted Greece to put its military on high alert and dispatch troops to the island, which are just arriving this week. It's understandable that this little island is so contested, because if Kastellorizo gets kind of part of Greece, becomes part of Greece's continental shelf, then Turkey essentially has no EEZ. How just are Greece's claims around the island? And do we have any historical precedent that might help us determine the fairest outcome here?
Mm-hmm. Yeah, let me start by outlining the rule. According to Article 121 of the Law of the Sea Convention, islands do have all maritime zones, are entitled to claim all maritime zones, namely the territorial sea, the contiguous zone, the continental shelf, and an EZ. That's the rule. When it comes to delimitation, though, international case law, examples from international case law show that in the majority of cases, small isolated islands get reduced effect in the delimitation process. That means that they don't get the same amount of waters as continental lands. Mm-hmm. However, we need to be careful because, as the International Tribunal for the Law of the Sea said, and that was also reiterated by the ICJ, every case that involves island, the delimitation of islands, is unique. And that's why we need to take into account the special, unique characteristics of each case. So we have Kastellorizo, which is a small, tiny island in front of a huge, long Turkish coast. And if we automatically apply the international case law, it seems that it will get a small enclave, a small water enclave around it. However, as I've argued elsewhere, there are special circumstances, relevant circumstances that we need to take into account. The fact that Kastellorizo is part of a broader island group, namely the Dodecanese. So we need to take into account the lengths of the coast of all islands, all the Greek islands in the region, Rhodos, Kastellorizo, Kassos, Karpathos. So it's not that simple. Of course, we also need to take into account security concerns. International jurisprudence supports the idea that we need to take security interests into account when delimiting a maritime area. As a matter of fact, in the Eritrea-Yemen case, the court did not enclave certain Eritrean islands in the Red Sea on security grounds. So there's several relevant circumstances we need to take into account before we draw a line, a maritime boundary.
So it's very complicated, which is why the world, Turkey and Greece have been unable to reach any kind of conclusion. You mentioned approaching smaller islands differently. One of the reasons Turkey calls for direct negotiations is that maritime borders is not the only issue. Another is the so-called gray zones, like the islet Greece calls Emia and Turkey calls Kardak, which nearly sparked a war between the two in 1996. Please, if you would tell us a bit about this issue and why it's still problematic today.
Well, yes, you're right. Whereas Greece supports that the only dispute with Turkey is the continental shelf delimitation issue, Turkey supports the view that there are several matters that need to be resolved. For instance, Turkey argues that Greece should not extend its territorial sea breadth from 6 to 12 nautical miles. Of course, we need to note here that territorial sea up to 12 nautical miles, it's an inherent right of every state. It is a unilateral act that does not need the consent of another state. However, since 1995, there's a casus belli decision by the Turkish parliament saying that if Greece extends its territorial sea up to 12 nautical miles, that would be a cause of war. Another issue is the demilitarization of the islands, of the Greek islands of the Eastern Aegean, the breadth of the Greek national airspace. So there are several issues that Turkey would like to discuss with Greece, but as we've said, Greece sticks to the continental shelf dispute.
Is that a reasonable approach on the part of Turkey? Has that been done before between other states, that they've brought in these other kind of relevant issues, but obviously separate issues?
Well, it's up to the parties, it's up to the states to decide what the differences, what the disputes are. There's no rule about that. If a state believes that there are several issues to be resolved, it has every right to say so. But on the other hand, another state can also deny that there's a dispute for a particular matter. So it's, of course, there are arguments from both sides. Others are reasonable, others are not. But we can, as I've supported elsewhere, the only way to resolve those disputes once and for all is through a judicial or arbitral process before an international dispute settlement mechanism.
Turkey earlier today, Monday, said it would extend its energy exploration in disputed areas of the Eastern Mediterranean until at least September 25th, despite the risk of European Union sanctions. You published a journal article last year, Nicholas, on drilling and seismic activity in undelimited areas, which I believe are areas where there are competing continental shelves or EEZs, as in the case of Turkey and Greece and Cyprus. You wrote in that piece that unilateral drilling or seismic activity should generally not be allowed in these areas, but you added that some activities may be permitted as long as they are done in good faith and do not put any final agreement at risk. Considering all this, how are we to view Turkey's activities in the Eastern Mediterranean in the past year or so? It sounds like they are not necessarily illegal, that there's some wiggle room there.
Well, we need to approach the matter. From two aspects. The first one is the case of potential violation of Greek sovereign rights, and the other one is a violation of the obligation of Turkey to abstain, to refrain from unilateral activities that might jeopardize the reaching of a final agreement. So Greece claims that the particular maritime area falls within its continental shelf based on the median line principle. So if we draw a median line between Greece and Turkey,
which is basically impossible to do because of the islands, but yes, okay.
Well, it happened before using islands in order to draw a median line. That's not impossible. It can also lead to an equitable result. We have a couple of examples in international case law. However, even if that's not the final result, we need to stress that an initial claim based on the median line is considered to be a good faith claim. So that's the starting point for international courts as well. When an international court is called upon to delimit maritime boundaries, it starts by drawing a provisional median line. And then at the second stage, it examines any relevant circumstances. And at the third stage, it checks whether the result is disproportionate or not. So the median line should be the starting point in any case.
Now, let me just say, before we started this interview, you sent me several images of maps. One of them is Greece and Italy and a vertical line going down the Ionian Sea. Is that their median line? And has it been effective?
Well, yes, there's an agreement in place since 1977 between Italy and Greece. That was only a continental shelf delimitation agreement based on the median line. And that's an example where the median line was exclusively drawn based on islands on the part of Greece, at least, and was extended a few weeks ago to the super-adjacent waters. So it's not only a continental shelf boundary now; it might be an EZ boundary in the future. So we can see how the median line has been applied between Italy and Greece. The same method was used in the Cyprus-Egypt agreement, Cyprus-Israel, and Cyprus-Lebanon. So there's a regional practice in favor of the median line, but that does not mean that the median line is binding on every state in the region. It's just a choice made by states in the region.
So what about the second part you mentioned, whether Turkey's actions endanger a possible final agreement?
Well, yes, that's the second aspect.
It seems like there's no way to know whether that's the case.
Well, since there's no delimitation, we cannot be sure about the outer limits of each state's maritime zones. So when there's no delimitation in place, we use the term undelimited maritime areas instead of disputed. It's a more neutral term. So absent the delimitation, the Law of the Sea Convention, Articles 74.3 and 83.3, stipulate that the interested parties should refrain from activities that might jeopardize or hamper the reaching of a final agreement. Of course, there's also an obligation to enter into negotiations in order to reach provisional arrangements. But in case they do not reach those, they do not conclude those provisional arrangements, there's an obligation in place that neither shall proceed with unilateral seismic surveys or drilling. So even if we accept that Turkey does not violate Greece's sovereign rights because there's no delimitation and we're not sure whether that area falls within Greece's continental shelf, there's definitely a violation of the latter obligation not to conduct unilateral activities in undelimited maritime areas.
You said there's an obligation to enter negotiations over kind of how long of a period? That seems like a kind of a vague phrase.
Well, according to international jurisprudence and state practice, a 6-month period is considered to be adequate for that.
As Turkey continues its seismic activity, searching for hydrocarbon reserves beneath the Eastern Mediterranean, it has also asked the Republic of Cyprus not to develop its discoveries, the Calypso and Aphrodite fields, until some resolution is reached on the divided island and related EEZs. To me, this sounds like Turkey wants to have its cake and eat it too. But how does the law see this? Does Cyprus have the right to develop its discoveries?
Well, the discoveries of Cyprus are located in an area which has been duly delimited between Cyprus, Egypt, and Israel. So there's no dispute there. It's not undelimited. So and Turkey has no claims, no maritime claims in that maritime area. So it's rather a political argument.
But it would say because of the northern Cyprus, that only Turkey recognizes, it does have some right to them.
Well, in order for an entity to be able to be entitled to claim maritime zones, it is necessary to have sovereignty over the coasts that project into that maritime area. The illegal entity in the occupied areas of Cyprus has no coasts that project into the southern waters of the southern coast of Cyprus. So, as I said, it's not a legal argument; it's rather a political one, supporting that the Turkish Cypriots need to have a share from that windfall, from that energy windfall. So it's not legal; it's not based on international law.
Now to the maritime borders deals. Turkey signed one with the Tripoli-based Government of National Accord, or GNA, in Libya last November. That deal, to me, seems unreasonable, and I'm, again, a total neophyte, mainly because it seems to just totally ignore or erase a sizable chunk of the Greek island of Crete. In response, last month, Greece signed its own maritime deal with Egypt, which is, of course, in direct conflict with the Turkey GNA agreement. Since Turkey signed that deal, I've spoken to a number of analysts who say that though its legality is questionable, the legality of that deal, of that agreement, that it likely gave Turkey more leverage at the negotiating table. I wonder if you agree, and if the same might be said of Greece's deal with Egypt.
Well, I would agree. I'd agree with you. Indeed, that agreement, with that agreement, Turkey scored points on the political plane. As regards the legality, according to Article 34 of the Vienna Convention of the Law of Treaties, it is quite clear that an agreement between two parties does not generate any obligations for any third state, especially when it comes to situations where a third state has legal entitlements for the area under the delimitation. And according to international jurisprudence, when two states delimit their boundaries and that delimitation has an impact on the legal rights, the legitimate rights of a third state, that delimitation is not definitive. So it's not binding on any other state, does not generate legal consequences for third states. That was the position taken by the European Council in December 2019, that the Turkey-Libya agreement does not generate legal consequences for any third state, because, as you rightly pointed out, disregards the rights of the Greek islands in the region. So there's a binding bilateral agreement. It's binding only on Turkey and Libya. However, that boundary is not definitive, it's not final, and does not generate obligations for either for Greece or any other state.
So I mean, the Turkey-GNA deal cuts across the planned East Med pipeline, for which Greece, Cyprus, and Israel signed an agreement this past January. But so they can just basically ignore the Turkey-GNA deal and go ahead with their plans, and they're not violating any international or maritime law.
No, because I mean, it's the maps are quite clear. The delimitation between Turkey and Libya overlooks fundamental rights of Greece. So it cannot be final, it cannot be binding on Greece or any other state. According to international law, that agreement does not have any legal consequences. So other states may use that area if they have rights in there. I mean, namely Greece, mostly Greece. Of course, there's another delimitation agreement between Greece and Egypt. That's a partial delimitation agreement. It does not did not limit the entire area, the entire common area between Greece and Egypt. And it is also noteworthy that it's not based on the median line, even though Greece has been a staunch supporter. Its long-standing position was in favor of the median line. That's not a median line. Egypt got a broader maritime space than Greece.
So then it sounds like these maritime deals of both Turkey and Greece are primarily political, not legal. But I wonder if do you think there's a chance that in any way they would potentially influence a decision made by a body like the International Court of Justice? Might they play a role in that decision making, or there's no chance of that?
Well, it depends on the relevant circumstances. As I said, the International Court or any arbitral tribunal takes into account a range of factors. However, if a delimitation agreement encroaches upon the rights of another states, the court won't take that agreement into account. That happened in the Nicaragua versus Colombia case in 2012, where the court disregarded agreements that were in place because it had an impact. They had an impact on the maritime area to be delimited between the two parties. So if an agreement is maximalist or overlooks legal entitlements, it won't be taken into account by the court.
Okay. As mentioned before, Turkey calls for a one-on-one direct negotiations, or possibly four-party talks, if we might include the Republic of Cyprus and Northern Cyprus, which again only Turkey recognizes. Greece, on the other hand, as we've said, would like to involve the International Court of Justice or arbitration from some third party. I wonder, which of these do you see as most likely? And how might each play out? Which do you think would have the best chance of reaching some final mutual agreement?
Well, on the one hand, the most likely option is negotiations, because Turkey does not recognize the compulsory jurisdiction of the ICJ. So it will be much easier for both parties to enter into bilateral negotiations, even though that's not the Greek preference. So even though negotiations is the most likely option at the moment, I believe that only through a judicial procedure, both parties would be able to present their arguments in a constructive way and give the opportunity to a third party, to an international dispute settlement mechanism with significant history, and it's a renowned institution, the ICJ, to draw a maritime boundary and put an end to that long-standing dispute. So I believe that should be the most that should be the preferable option. Submit the case to an international court or tribunal.
So you see negotiations as most likely, but you think an international court or tribunal is the better option.
Yes, indeed.
Why is that? Why is that? Just because you think it's more likely to reach an agreement, or because Turkey has some advantage if it's about negotiations? Why is that?
Usually powerful states are reluctant to submit the disputes to an international court because they would like to have control over the process.
And they have greater control if it's negotiations, right?
Yeah, they may exert pressure on the other party and achieve better results for them. On the other hand, when the dispute is when they have recourse before an international, impartial, in principle, body, the outcome is more equitable. So both parties have the opportunity to present their arguments, and then 5 or 15 or 21 judges, depending on the body, are about to deliberate and hand down a judgment, an international judgment, which has, as you can tell, very important. It would be a very important outcome and has a bears significance on the international plane.
Mm-hmm. So you see negotiations as most likely. I wonder what sort of compromises do you see as most likely from either side in terms of their legal maritime claims? Where do you think Turkey and Greece are most willing to give ground to reach a deal?
Well, I can't make any predictions. That's.
But you understand the kind of the scheme here, the field here more than most. I wonder if you just give us a little bit of insight, kind of what your view is.
Well, perhaps Greece is willing to accept a deviation from the median line, but I don't know to what extent. So perhaps the outcome would not be a median line, but I don't know where Greece would draw a red line. So that depends on many factors. That's why I can't make any prediction.
Mm-hmm.
And I don't know if there will be, even if there will be an outcome from that process, from a negotiating process. There might be a deadlock as well.
But do these disputes sometimes last decades, or do they often last decades and kind of go unresolved for lengthy periods of time? And then if that's the case, what, in most cases kind of ends the deadlock? Is there something that often happens?
Well, either the parties decide to make mutual concessions or submit the case to an international court. Or just leave it there. So it's up to the parties. I mean, there have been the two, Greece and Turkey, have been discussing on that for decades. I mean, they've conducted 60 or 70 rounds of bilateral discussions on the Aegean dispute to no avail. So it's quite unpredictable. That's why I'm not very optimistic about it.
Mm-hmm. And one last question for you. In a lengthy piece for Cairo Review last week, analysts Henri Barkey and Ellen Leipson argued that, quote, events regarding the new energy resources of the Eastern Mediterranean are moving in favor of the Israel, Greece, Cyprus, Egypt coalition as of mid-2020. Turkey is the outlier, attempting to limit, if not undermine, any new multilateral regional institution, which was a reference to the recently created Eastern Mediterranean Gas Forum. The EU has consistently backed its member states, Greece and Cyprus, unsurprisingly, and the U.S. last week partially lifted a long-standing arms embargo on Cyprus. But setting aside the politics, I wonder if you agree with this idea that the past year or so has in some ways played to the advantage of Greece and Cyprus, and that Turkey's posture has lost some ground. I mean, might a body like the International Court of Justice or some other see it that way?
Well, that's one of the arguments I make in my forthcoming book, that the regional states have decided to act in compliance of international law in order to cooperate and avail themselves of the energy windfall. That's why they've signed the limitation agreements, they've signed framework agreements for joint exploitation. They've conducted the trilateral meetings. So there's this network of cooperation in the region, and all states, majority of states, are willing to cooperate under the guise of international law. However, Turkey is the different drummer in this case. So they act contrary to international law. They put forward maximalist claims that make cooperation with other regional states impossible. So I believe that the key to this situation is the implementation of international law. All regional states need to act in conformity to international law in order to avoid tension and enhance cooperation that will bring economic and political and geopolitical benefits in the future. That's my view.
So just to be clear, are you saying that if the case did go to the International Court of Justice, Turkey would potentially be at a disadvantage because it has, in the last year or so, appeared to act contrary to international law?
Well, yes. Whereas the rest of the states were acting in compliance with international law, Turkey has not. It has not acceded to the law of the Sea Convention either. So even though Turkey seems to invoke several international law rules, it interprets them in their own way. That it's not in agreement with the general application, with general international law. That's why they've been trying to introduce deviations in the application of international law in the region, and that's not feasible. That won't be acceptable.
That's interesting. That would seem to give Turkey even more reason to avoid going to a body like the International Court and prefer negotiations.
Well, yeah, but they can also change their posture and try to act according to international law in order to avoid tension. If they actually apply international law, there might not be a need to have recourse to an international court. They might be able to resolve their disputes with the neighbors through bilateral talks or multilateral talks. It's quite awkward having all states on board. As you rightly mentioned, the
East Med Gas Forum.
East Med Gas Forum. The limitation agreements, joint exploitation agreements, and Turkey has chosen to remain outside that cooperative framework network. So it's their own choice. I believe that if they show some willingness to collaborate with the rest of the states, that would be well received by the rest of the states. Nobody wants tension, and because nobody can, if there's no stability, there's no peace in the region, the extraction of hydrocarbons would be difficult. So investors won't be willing to put the money in the region. So I believe that it will be for the common good, for the benefit of all states to collaborate according to international law.
We'll have to wait and see if that happens. Nicholas Ioannides, professor at the University of Nicosia, thanks so much for your time and insight, and I'm looking forward to that forthcoming book.
Yes, thanks a lot, David.
It's been a pleasure talking to you.
My pleasure as well.
You can follow Ahval News Online podcast series through Apple Podcasts, Spotify, YouTube, Google Podcasts, SoundCloud, and Spreaker. All you need to know about Turkey is here, for your ears, mind, and attention. Thank you for listening to our podcast.